Hello everybody, this is Dr. Cole. Monday morning, November 9th, heading into week 13 of Con Law, Political Science 3753 for the fall 2020 term. Everybody, we're going to chat online tonight in preparation for quiz number 7 tomorrow. Tuesday, it'll be available for you to take all day. Tuesday, 24 hours. And we'll chat for 45 minutes in the chat room tonight beginning at 7 p.m. Central Time. There are any number of cases, recent cases from the 2020 term that are discussed in this material, and they're related to some earlier cases that are discussed in your class notes, and I wanted to talk about a few of these cases for just a few minutes. Before I go any further, everybody remember, everyone is required to submit a term paper. We had put out a list of recent cases that students had used for their topics. Once you settle on a topic, and it could be a single case or maybe a couple of related cases, just mention that to me in an email if you would like. And I'd be happy to get back to you with any guidance or pointers that I can provide. But remember, we're 3 or 4 weeks away from having to submit that at the end of the term. That is a requirement of the course. So everyone will want to be getting to work on that if they have not done so already. So if you'd like to talk about your choice of topic with me, I'd be happy to do so. Now, the readings you have, we gave you 4 short articles. And these articles mention one or more of the religion cases that were decided by the Supreme Court before they ended the 2019-2020 term back in June and July. One of these was the Little Sisters of the Poor case. Little Sisters of the Poor versus Pennsylvania. This goes back to the Hobby Lobby case from a couple of years earlier. Both these cases involve the mandate to provide contraception coverage in the Affordable Care Act, Obamacare. Okay. Some employers objected because of their moral and religious beliefs. Okay. And back in 2014, the Supreme Court granted an exemption to the Hobby Lobby company, a privately held, family-held company, does not trade shares on the stock exchange, completely held by the family. Now, the homeless shelter, I believe it was, for elderly poor people that was being run by the Little Sisters of the Poor, that's a different category of employer. So somewhat different questions were raised. The Trump administration issued guidelines to protect employers such as the Little Sisters of the Poor from having to abide by the contraceptive mandate. The state of Pennsylvania sued. It went all the way to the Supreme Court. The Supreme Court found in favor of the Little Sisters of the Poor. So that's what happened in that case. Then there's the case of the Our Lady of Guadalupe School. Okay. Our Lady of Guadalupe School versus Morrissey Beru. Morrissey Beru was a teacher who was dismissed by Our Lady of Guadalupe School. The facts of the case are kind of complicated and convoluted. They wanted the teacher to become certified to teach catechism courses because they were running short of teachers. Well, the teacher in question was not a practicing Catholic and had taught in other academic areas besides that. They dismissed her. She pleaded that she was a victim of age discrimination under federal anti-discrimination statutes. And the court, drawing on a precedent from a couple of years earlier in the Hosanna Tabor case, which is in your class notes, invoked the so-called ministerial exception, in which schools such as these claim that just about all their teaching staff amount to ministers, and so it would be an interference with their free exercise rights to apply federal anti-discrimination law to their employment decisions on which teachers to retain, which teachers to renew their contracts, and which to dismiss. And the court found in favor of the school in all these cases. The first case going back to the year 2012 and the more recent one from just a few months ago. the Our Lady of Guadalupe school case. All right, now everybody, as you look at your class notes on religious freedom, the class notes for lectures 23 and 24, 23 involves such matters as cases where students in schools were required to say the Pledge of Allegiance at the beginning of the school day, that some religious believers objected to as tantamount to an act of worship. Eventually, the Supreme Court carved out an exception and relieved such people of that requirement. The case of religious displays at holiday time in front of a public building. There have been some very contentious cases involving that issue. Now, in Lecture 24, what you find are cases involving the treatment of religion in the schools, and in particular, assistance by public authorities using taxpayer funds for religious schools. Now, the problem is religiously devout parents would like to have their children's religious education as part of their general education. But we have interpreted the Establishment Clause of the Constitution as raising a very strict wall of separation. And so parents who want that religious education as part of their children's general education have to pull their kids out of public school and pay tuition to private religious schools. Okay, and it's a contentious situation. What you read about in the class notes for Lecture 24, by and large, are various attempts to get around that interpretation of the Establishment Clause. Now, the recent case we have that the Supreme Court decided just a few months ago was the case of Espinoza versus the Montana Department of Revenue. Montana had a tax credit program. You get a small tax credit if you donated to a scholarship fund to allow poor people to send their kids to private schools. But they had to be secular schools only, under a provision of the Montana Constitution that's known as a Blaine Amendment. And you'll be reading about that in the column by George F. Will that I've assigned to you. Okay? The Supreme Court ruled against Montana and said that Montana did not have to subsidize with a tax credit any sort of private schooling at all. But if they did, they couldn't exclude religious schools. That was the case of Espinoza versus the Montana Department of Revenue. All right, so those are the cases you'll be reading about. Those 4 articles you've been asked to look at discuss one or more of those 3 cases. Now, as you do that reading, you'll find that some of the other cases mentioned in your class notes are brought up. In that article by Linda Greenhouse, you'll see a discussion of the case of Employment Division versus Smith from 1990, which is an important case. What happened in that case? Some employees in Oregon had been dismissed from their job because they smoked peyote. They argued that they were members of the Native American Church, and smoking peyote was part of their religious ritual that they practiced. But that was against the law in the state of Oregon. Okay. When they applied for unemployment benefits, they were denied because their loss of employment came from breaking the law in the state of Oregon. They pleaded to the Supreme Court that their free exercise rights were being interfered with. But the Supreme Court found for Oregon. Justice Scalia, the late Justice Scalia, wrote the opinion in this case. And his concern was that we were too often providing exemptions from generally applicable laws for religious reasons. The problem is we do that sometimes. Not always, but sometimes. For instance, you will read about the case of Wisconsin versus Yoder from 1972, in which the Amish people in Wisconsin pleaded for an exemption from the compulsory education laws. They wished to educate their children themselves after the elementary school years, and the Supreme Court granted them an exception. They said their free exercise rights overrode the interest of the state of Wisconsin in that case in enforcing the compulsory education laws. Okay. All right. Now, after the Employment Division versus Smith decision came down, Congress soon thereafter, just a year or two later, passed the Religious Freedom Restoration Act that came in 1993 after the Employment Division versus Smith case came down in 1990. Okay. And in that law, Congress required the courts, they in effect attempted to at least partially overturn the decision in the Employment Division versus Smith. They wanted courts and legislatures to provide religious exemptions, to provide accommodations for religious practices, to defend the free exercise rights of people with particular religious beliefs, unless there was an especially compelling reason not to do so. Okay, so that was a reaction by Congress to the 1990 decision in the Employment Division versus Smith, which was an important decision, which you'll read about in the article by Linda Greenhouse that I've assigned to you. So, we will chat about all this tonight, and we'll take the quiz tomorrow on those 4 short articles I've asked you to look at. Once again, do be thinking about your term papers and the cases you'd like to talk about and discuss in your term papers. And we will see some of you in the chat room tonight. And we wish you good luck on the quiz tomorrow. And otherwise, take it easy.